Fuck's sakes. Right, I did not realise I was muted. I was saying hello to everybody. And I was like, hello everyone. I even gave you a shout out, Trish, saying that I love and adore Trish, even though she makes me wait forever. Hope you're doing well, my darling. Um, Paul, how are you, Lynchy? Rhonda, everybody, Lady Di, Bad Dazza. I was just saying nice things about all of you. But that is negated now. Right. Lisa, how are you, my darling? Nice to see you. Test speaker mics. I don't need that. Speaker. I can't hear that. Right, hang on. Can we hear this? I can't hear that. That's not a good start. We will try and do this properly. If not, then we'll just push you over to somebody else to watch it. But I think everyone's streaming it from Zoom. I just not done Zoom for ages. That's the problem. Everyone say muted. I'm not muted anymore. I'm not muted anymore. I am back. Guess who's back? Back again. Right. How the frig do I do this now then? How do I do this? KD, hello to you, my darling. I hope this works. I don't know if the volume's going to work or not. It says test speaker, but then when I test it, I can't hear anything. Oh! Hey, Just Jugs. I can hear it. Happy days. Can you all hear that as well? I'll play it again. I hope. Oh shit! I hope you can all hear that. It should be a piano noise. Oh, Boston 7 do they? Oh, if they have a pool camera, happy days, KD. If they do, hang on then. Yeah, that's what I've been waiting for. If they got a pool camera, we'll do the pool camera. Boston 7. Hang on then. I miss American Pie. Boston News 7. Nothing at the minute, but we'll still keep an eye out on it. Unless, has anyone got it? Can anyone find it for me? If you can, DM me it. Because I can't find it. So if there's a pool camera, let me know and I will put that on. Hang on. Live. Okay, no, nothing there. And shout out to Erica and to Dina as well. They are out there covering live. They smashed it today. Absolutely smashed it out there today. Which was amazing. It's good to see there. So I can't see any stream yet. So if anyone does find a stream, let me know. As in Boston 7 or anything. They're not doing it yet anyway. So anyway, it's fine though. We'll get into groove it. I am on obviously Zoom here, so we should be able to just to go in via that. Hello Christine, this is Aidan Kearney's hearing today. I don't know which hearing this is. I'm not up to date with everything, to be quite honest with you. But I hope you're doing well, Christine. Also, those of you who are members would have seen my disaster of a stream yesterday. If you haven't, go and watch it. Of how I am now on Streamlabs and not StreamYard. But it was a complete disaster. But we're still here though. It's fine. Okay. The only bad thing is I can't put the chats up and I have to rely on the screen to see the chats. So forgive me that I'm not able to put them up as always. I always time I see Trish as a child of God, I always think of sweet child of mine. Boom, boom, boom. Oh, sweet child of mine. So anyway, that's the end of that. No one's saying anything, so there can't be a stream out there because no one's saying anything to me. So there can't be anything out there. Right, which is fine. So that means they haven't started, and from what I see, no one else is streaming anything. So we're all good, people. We are all good out here on in the hood. We ready? It's Friday, so we all ready for the weekend. Are we all ready for the weekend? Do we have any? Thank you, Yaya. You're always good. Yaya's always good. Wicked Psych, hello, my darling. Hope you're doing well. Right, we're here. Are you here to support? Ah, there you go. Thank you, Rhonda. Are you also here to support Aidan, Turtle Boy? If you are, drop the turtles in the chat. I can't. Can I do it? Hang on. If I open the chat, where do I open the chat? This is like literally multitasking 101 right now. I got about 100 tabs open. I'm trying to figure out where I am. Right, is this my chat? No, that's not my chat. Where's my chat gone then? I hate this. This is so unprofessional of me, I know, but this is me. This is me. Oh shit, that's not good. Just had a notification saying your stocks have nosedived. Oh fuck. Please smash the button. I can't sign into chat. Right, let me sign into chat. See where that takes me. Oh, here. That's why. Okay. Right, let's see if I can put some turtles in the chat. Because I don't know how to do emote turtles. Oh, here we go. I got them. Here we go. Right, also, Spacey Stacy and Hippie Chick have been busy on the street this morning. They've been in about 10 different streams already this morning, so they're tired. But I can't play the song, Stacy. Well, I can, but not at will, because it says a host has joined. We'll let them know you're here. Okay, thank you. Thank you very much. Good morning, Jodie, my darling. Jodie Mitchell, as you all know, I am Peabody's Champions Pub #1 fan. So Jodie's in the chat for Peabody, my favourite place in Boston. I hope Phil's doing well as well, Jodie. And you know what? I've enjoyed the pictures, you and your granddaughters and everything. They've been awesome, Jodie. Hope you're doing well, my darling. Send my love to Phil as well. So go up to him and give him a big hug from me. He'll be like, what the fuck? Hello, Karen. How are you, my darling? Nice to see you, as always. Forgot the P. Oh, here we go. Scooby. There he is. Scooby-Doo. How are you? Thank you for the donation, Scooby. That might be a bit too big. No woman has ever said that before, but I'll say it. That might be a bit too big. As I say, that's not something we normally say. Right, hang on. Let me... Oh, I love the Patriots, Karen. I love the Patriots. Hey, hippie chick. I know, I can't play it. Ah, thank you, Phil. Got a love for the Mitchells. Right, let me figure out how I do this. Window capture. Right. Audio. Okay, I think that's fine. Alert box is there. Right, I'll make that a little bit big, smaller. Sorry, ladies. Just because it's too big. Okay, got that done. Let me lock it in. I think we got it. Yes. Right. Let me just do another drive through to see what else is happening here. Hope you're doing well here. I like having a small little chat here. It is nice. It's good. Because we don't have to. Yeah, please like the like button, please. I'm sorry. I'm trying to look at Is any of this? No, still no live stream from Boston 7. I'm sure it will come, but it's not there yet. Yes, please like. I don't know how many people liked it. I can't tell who's liked it and who hasn't. So on the new Streamlabs settings, it doesn't tell me. I have to go into it to see. So let's have a look at this to see how it works. There you go. It works that way. That's fine. That's a bit better. How do I mute the thing though? Oh, here we go. Here we go. We're in. Right, I can't. Here I am at the top. I can't hear myself. Hang on. I need to. I think the mute is them, as in I just went into Melanie's chat and she hasn't got audio either. So I'm muted, which is fine. Oh, hello. So I think it's the no, it's no sound, Wicked. I think that is the court, not us though. Thank you everyone for liking the stream. Missy Lurch. I think she's a troll, isn't she? Is she one of those that hates Aidan? So the audio works anyway. That's embarrassing for her. And you see at the top, the alternate corners at the top left hand side. Hey! Let's go! We're famous. Sweet child of mine. Still no pool camera. It is her. Is it Hippie Chick? It is her. Yeah, I muted myself, just because I was trying to listen to Melanie's stream to see, but she didn't have anything either. So that's Missy Lurch. That's one. They're very anti. Why? Right. Question. Right. If you hate Karen and if you hate Aidan so much, why are you listening to his hearing? Like, if I hate somebody, I don't watch them. I haven't got the time for all that bullshit. Get on with your lives, people. There are a couple of people I hate in this world, and I do not watch them because I have my own sanity to look after. So I don't really get it. I don't really get it. Listening to say, but couldn't hear it. Fine. I said don't like people. I want a man hating revenge. Oh, you want a man hating revenge? Is your husband giving you shit? And I'm glad if he is giving you shit, Lady Di. Trish. Morning lady, preach. It is Jody. I don't get it. I just don't get it. I just don't get it. If she was to say, look, I hate Aidan and whatever, fine, but I support his fight for injustice, I get it. But they don't. They want him in prison. They want him in prison, and they don't understand that if he ends up in prison, it could be them next. It could be you. It could be me. Anything. I don't care what you think of Aidan. He's had nothing. He's been nothing but nice to me, so I got no issues with him. If you hate him, fine, but he doesn't. He shouldn't be going to prison. That literally could be any one of us. You know, and to be quite honest with you, he's got bigger balls than I've got, and what bigger balls than what most of us got. Because I couldn't do half the stuff, you know, that he does. So I give him credit. Paul, I think the last person that speaks, they come on screen. So once the judge comes on and stuff, it will leave that. Um, Lady Di says he's listening, and I'm about to kick his broken ankle because he's agreeing with you. You see? You see? Mr. Lady Di, you can't disagree with me anymore now. Right, how do I... Oh, is it... Hang on, I think there is... Is there... Is there a pool camera? Hang on. If there is, I'll go out with this. No, how the frig has she got that then? Oh, that's how you do it. Okay. I didn't realise that. I'm a newbie, people. I'm a newbie, sorry, people. Scooby is back. But some people are just stupid, Lanny, and should have been swallowed. There's so many people in this world that should have been swallowed. There is so many people that should have been swallowed. I'll be honest with you. And I totally agree with you. It's a nice crowd for Aidan, which is good. Oh, I've got the wrong one. Have I got the wrong one up? Hang on. Let me do this. I'll just do this instead. That's a better one. Oh, Jim, I presume that's Aunt Bev. Hickey, I don't know who had a Hickey when they were younger. I don't know who Hickey is. AML Media, no idea who that is. PF iPad, I don't know who that is. The Court, and there's me. Right. I got just too many tabs open, so it doesn't help. Let's make it a bit bigger. I'm going to hide the chat for a little bit. Oh, I can't. Hang on. It's a pack courtroom. Let me make the screen bigger, people. Hang on. No, where is it gone? Hang on. Let me make this one. Hang on. That's the wrong one. Ah, yeah, it probably is. You're right. You're probably right. Attorney Melanie Little. You're probably right. I don't know why. Hang on. Window capture. Let me make this up the top somewhere then. Do you know what? I don't. Lady Di. There's a load of supporters for Aidan, which is great. I'll say, here we go.
prepared to come out at 9, but the delay was due to the late arrival of some of the council. So with that, I would remind all parties who are attending by Zoom that any rebroadcast, if you are not qualified under SJC Rule 1.1119, rebroadcast is prohibited. Those who are qualified and have registered are certainly free to rebroadcast as appropriate. So, with that, my intention today is to cover papers 110, 117 in part, 125, and 127. Those are the matters which deal with the request for the recusal or removal of Mr. Cosgrove as counsel for the Commonwealth. Now, before we begin that, particularly Mr. Bedrow, just to you, and I know Judge Doolin may have talked to you about this a little bit. Going forward, we don't file affidavits as motions. Rule 13 requires a motion to be a motion. It can be supported by a memorandum of law. It can be supported by an affidavit. The matter we're here for today, there is in fact no motion on file. I'll take it as it sits because it's been responded to. But going forward, if you want to file a motion, it has to be a motion. It has to be clearly captioned as to what you're looking for. Further, it has to deal with one subject at a time. I'm not going to do motions that deal with the entire kitchen sink. There'll be one motion at a time. It's going to be clearly noted. If you want to put a memorandum of law, again, you have to reference the motion you're dealing with. Further, if you want to put an affidavit, the affidavit has to reference the motion that you filed. If you want to put in a supplemental motion or a supplemental memorandum, it has to list the paper number that you're talking about. Going through this over the last several days and trying to figure out what I'm dealing with took an amount of time, which is kind of absurd because I'm trying to trace back what you're talking about and I can't find the motion because it doesn't exist. So I understand you're not local to Massachusetts. Mr. Bradley is extremely experienced and quite good at drafting these things. So
I was going to say that's my fault. I'm local counsel. I should have made sure that was that way, and we'll make sure that going forward.
And I note that paper number 127 is more in the form that we used to in this court. So I just want to remind everybody where we're at. And again, not familiar with the area, that's okay. Just going forward, I don't want to have to sort of parse through what we're dealing with, nor do I want to have to hear from Mr. Cosgrove saying there's no motion filed, because it's a pretty good point on his part. So with that, let's take up the matters that are before the court. You're the moving party. I don't know who wants to argue, Mr. Bradley or Mr. Bedrow.
Mr. Bedrow, Your Honor.
We'll hear from you.
Thank you.
I understand. I've looked at all your motions as well as all of the exhibits.
May I, Your Honor?
You may.
Counsel states that a recent conflict of interest has developed, which ethically precludes him from continuing to prosecute matters in which Lindsay Gaetani is an alleged victim or party. Those are the words of Mr. Cosgrove on September 24th, 2025, regarding his request to be removed from another indictment in which Lindsay Gaetani was a witness, and we'll get to in this argument why she may very well be a witness in this case.
Witness is different from victim, correct?
I'm sorry?
Witness is different from victim, right?
Of course. But as we'll get to, Your Honor, if a prosecutor or anyone has a personal interest that may differ from Commonwealth's or to a defendant's right to a fair trial, that's something that has to be factored in. The point of that comment, Your Honor, is that Mr. Cosgrove acknowledged that there was a conflict arising out of Ms. Gaetani's claims against him. She has accused him of unprofessional and unethical conduct and has sued him. He draws the line.
I know that the docket entry in that case was in the process of being settled. That's paper number 15 in that case that was filed just last week.
Judge, whether the civil case continues or not isn't even necessarily the issue.
Explain why that would not be a problem.
Because she has accused him, a former judge, of unethical behavior, and he has a personal interest, understandably so, defending himself against that. And in any matter in which her credibility becomes an issue, she testifies in a trial, he has an interest in discrediting her, which may be very different from the Commonwealth's interest, which I'll get into as to why that may be. But the point is, calling her an alleged victim and that there is a conflict because of her allegations against me merely being a witness in a case in which she may testify, as the difference which somehow makes his personal interest, acting both as a criminal prosecutor while serving as a civil defendant and potentially cross-examining your civil accuser and your lead detective, is a civil co-defendant who has also been accused of misconduct, undermines the public confidence in the proceedings and demonstrates that a prosecutor could have a personal interest. The bottom line, Your Honor, the difference between witness and alleged victim is a distinction without a difference if the prosecutor has a personal interest which could significantly impact his representation of a party in the case. That's the Rule 1.7 issue. Now, Mr. Cosgrove has replied to call Ms. Gaetani as a witness, and that certainly is right for the time being anyway as the prosecutor for the Commonwealth. But the defense may very well call her. Her credibility will be certainly it would with the direct examination of her.
Well, he's not going to call her. He's made that clear.
I understand that. What I'm suggesting to the court is we may very well do that.
You may, and you'd have to get permission from the court to do that because you'd have to show me that it's relevant, but that's another issue down the road.
Well, I'm going to tell you right now, respectfully, why it may be relevant beyond just the substance of her testimony. Mr. Cosgrove addressed the substance of her testimony as it relates to the allegations against Mr. Kearney. She also may very well be a witness who can expose bias of other important prosecution witnesses, who could expose conduct on behalf of some of those important prosecution witnesses, conduct which is not at all consistent.
Well, let's get to the nub of it, all right? Because I've read all your material, so you don't need to repeat the argument to me. Look, as I understand the issue here, Ms. Gaetani, that's the correct pronunciation, is it not? Ms. Gaetani has an interaction with Special Prosecutor Mello in December, I think the 24th, was it, or the 23rd?
Something like that.
Of 2023. Mm-hmm. It's around that time that she's alleged to have some interaction with Ms. McCabe. Is that correct?
Among other times, yes.
Well, around that time is my understanding, based on the evidence you presented me, around that time Ms. McCabe urges her to go to the grand jury. Do the right thing, go to the grand jury, something along those lines. All right, is that correct?
In substance, but I think it's interpretational, and the witness might expand upon that.
I understand that. All of those events occurred 6 months after the events that are in play here. So the relevance of those events is only as to the credibility, potentially, of Ms. McCabe. Now, you might be able to get into that. You might be able to even confront Ms. McCabe. But then you're going to have to raise an issue of whether or not you get into a trial within a trial, so to speak, the extrinsic evidence rule, which takes us to whether or not she is even going to be a witness to talk about potential bias after the fact. This is after the fact bias.
Yeah.
On an issue which, frankly, I'm struggling with a little bit because nobody contests the acts here, all right? Mr. Kearney is a citizen journalist, sort of a new breed of journalists, correct? He presents to this court that all of his activities are fully protected under the First Amendment. Very reasonable argument, okay? Mr. Cosgrove says different. He says this is witness intimidation. The motivation of Ms. McCabe to his acts is tangential by and large, is it not?
Judge,
now, she's going to testify, yes, I was intimidated. But the main factor here is the nature of the comment, which is recorded, made voluntarily and recorded. Now, you are correct. There's an excellent argument to be made, perhaps, that Gaetani and Genduso and McCabe may have all had some idea that they were going to get together and get his bail revoked. But that's not what this trial's about. This trial's about what happened 6 months before. So you got to draw me to the relevance of that.
Well, her bias and motive against him, whether before, during, or after, I would suggest is certainly relevant. Moreover,
But it's all after. There's no before.
Judge, you mentioned a moment ago about the fact that she's going to come in and say, I felt intimidated, or I was emotionally harmed. I think we would all agree that would be relevant about what the impact that these horrible allegations had on her. There will be evidence through electronic communications between Gaetani and McCabe, which Gaetani may very well have to authenticate as a witness, because frankly, we don't assume or take any guess what Ms. McCabe will say, where shortly after Mr. Kearney was released from jail, from what Your Honor just spoke about, where Ms. McCabe recruited Ms. Gaetani and orchestrated surveilling him from various police stations and to other locations, joking about going on a stakeout. In other words, conduct not consistent with her being intimidated. Those actions will also
The intimidation doesn't have to last forever. The intimidation, we're only trying one slice in time. That's the bedrock of any criminal defendant, right?
But
we're not trying his entire life, we're trying that moment.
But these are questions that have to be posed to Ms. McCabe, and she'll have and should be forced to answer them and explain them.
I don't necessarily disagree with that.
Okay, so the point is, we don't know what Ms. McCabe will say. We know, based upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
Which seems to move with time from poll to poll, correct?
I'm not sure what you mean.
Well, it seems like her allegiances have changed as this case has developed.
She is, without question, a unique witness, which raises another interesting point, which could lead to the possible conflict with Mr. Cosgrove. She is a former prosecution witness. There's no question. She testified in grand jury. She testified at a trial called and vouched for by Mr. Cosgrove.
Quite enthusiastically, as I understand.
I believe so, Judge. No question. And at that point, they had no problem with Ms. Gaetani. But at this point, she's now sued Mr. Cosgrove. She has sued Tully. She has threatened to sue or sent a demand letter to the DA's office. And when that happened, Mr. Cosgrove said, I have a conflict with her because he has a personal interest in seeing her discredited. And I'm going back to what I first started with, Your Honor. The issue is not because she's an alleged victim. She's a potential witness in this case, and the prosecutor has a personal interest in seeing her discredited. And the critical part comes in the argument to the jury at the end of the trial. When McCabe has testified, it's in Mr. Cosgrove's personal interest that she be credited, Gaetani not be credited. When Tully testifies, it's the same exercise. He's a co-defendant of his.
What's Tully going to testify to?
Is Tully going to testify? We're not calling Tully.
Mr. Cosgrove, what's Tully going to testify to? Is he even a witness?
I have no determination as to whether I'm going to call Lieutenant Tully or whether I'll need to call Lieutenant Tully. It seems to me that the videos, which Mr. Kearney has himself made public, documenting his statements and actions, are pretty much self-authenticating. I'm not sure.
Well, I think he may have to make a choice here fairly quick if we're going to deal with this issue. But continue.
Look, the bottom line is Detective Lieutenant Tully is the lead investigator on this matter. Now, that doesn't obligate the Commonwealth to call him, but he is the driving force behind this. He built the investigation. He got the search warrant.
This is not your classic whodunit.
No.
This is not the investigation where they find evidence on a scene, they develop the evidence on the scene, they trace the suspects, they get phone downloads, they do this, that, the other. This is a very unique set of facts. Where the defendant recorded himself and then voluntarily broadcast his actions to the world at large. So there's the investigation essentially is press record. And then a jury of his peers, all right, would judge the mores of our society to determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
The point I'm making, Your Honor, is that
And I would like the jury of his peers to make that decision. I don't want to make it. I want the jury of his peers to make that decision.
The point I'm making, Your Honor, is on this issue is that Tully is the lead investigator. And certainly I can only speak from my own experience, perhaps others, that it would be extraordinarily rare not to call.
I don't find that to be accurate in my experience. I've seen it happen a number of times, much to my disappointment when I sat over there, okay?
I've seen it happen, and I've taken that from the other side of the table in prosecuting rather than defending, in letting juries know who built the case, what is going on here. But the point...
And fairly pointed out by the defense, and you didn't hear from him.
It could be. It may very well be, but that could also lead to the reason why. Okay? The issues surrounding Gaetani's claims, the defense wants to argue they're not calling Tully. Perhaps the jury may be entitled, not asking Your Honor to make evidentiary rulings now, obviously, but the jury may want to know and be entitled to know why isn't the prosecutor calling him, and might it have something to do with what Gaetani alleges. But moving away from Tully to the larger point, it's not even so much the cross-examinations, or other evidence, which I would suggest are improper being conducted by a prosecutor with a personal interest in favoring certain witnesses over the one that is suing him. It's the summations, it's the argument. If Mr. Cosgrove has an opportunity to cross-examine Ms. Gaetani, assuming he does, as Your Honor noted, maybe he won't, but I would suggest, again, that's a decision to be made by a disinterested prosecutor, not one with a personal interest.
Well, let's define the personal interest. It is, anybody can bring a lawsuit against anybody, all right? You know, the actions that are alleged here by Mr. Cosgrove, and most of them appear, frankly, seem to have occurred prior to his arrival in the case. But the actions are alleged were done solely in his role as a special prosecutor. You know, his immunity is almost impenetrable, correct?
In a legal sense.
Sir, this is a legal setting.
No, Your Honor, my point is this. Personal interests don't rise and fall. They're not black and white because you've been sued or not sued. She has publicly and loudly accused a distinguished prosecutor of misconduct that he himself recognized after the lawsuit was filed. This lawsuit that we're saying has no merit, what did he do? He sought removal because I'm ethically precluded from cross-examining her. It's the same issue.
Well, I'm not sure about that. I'm not sure that's what he said, but I'll take that for what it is.
Well, Judge, I just want the record to be clear. What he said was, counsel states that a recent conflict of interest has developed which ethically precludes him from continuing to prosecute matters when Gaetani is an alleged victim or party, and we talked about whether we use alleged victim or witness as the issue. The point is...
Well, that's why I said that's not exactly what he said. What he said was...
Yes. No, I'm not trying to substitute that. We're trying to, in my view, suggest that's a distinction without a difference, because he has been attacked, and when he withdrew from the other case, the lawsuit against him was no better or no worse than it is now. So he didn't make that argument back then to say, this is some garbage lawsuit, I have no real conflict. What he said was, I am ethically precluded.
All right, I take your point. Mr. Cosgrove, if you're ethically precluded from one, why aren't you ethically precluded from two? I'll come back to this issue of the 2025 investigation, too.
I reserve my answer on that.
Reserve it for when?
When it's my turn to speak.
I was about to give you your turn to speak, but I'll go back to Mr. Bedero. Let's talk about the 2025 investigation.
Your Honor, can I make one point I didn't get to? We kind of got. It's the summations where the real problem arises here. Because if Gaetani were cross-examined by Mr. Cosgrove, in essence, it is almost a free deposition. It is sworn testimony of her by a litigant against another litigant in a civil matter in which he has the full power of the government cross-examining, which will benefit his personal interest. Then you go to summation. Presumably, his argument will be Gaetani is not believable, Gaetani is not credible, but McCabe is. Now, those are appropriate arguments by most people to make, not him, because it is in his personal interest, not just as a representative of the Commonwealth, it is in his personal interest that she be discredited. And the jury should know that. Now, I'm not saying that's an appropriate outcome either. The appropriate outcome is that he be removed, because if he's vouching for the credibility, not in an illegal sense, but advocating for the jury to adopt Jen McCabe and discredit Lindsay Gaetani, the jury should not be ignorant to the fact that this guy's getting sued and wants her to be discredited. That is not the kind of thing that the public can have confidence in when they find out that the prosecutor who is judging everyone's credibility is discrediting her, crediting another, and it's tantamount to him giving unsworn testimony.
This goes back to the issue of relevance that we talked about before, and this is where I'm a little bit hung up. What McCabe does 6, 8, 10 months after the allegations here, because the allegations with regard to McCabe, as I can tell, they occur on 6/6, 9/20, and 7/22. Those are the 3 dates where she's alleged to have been intimidated. So none of these matters involving Gaetani develop until perhaps December, right?
Gaetani's, some of her testimony, though, Judge, will corroborate other evidence we have of Jen McCabe's pattern of surveilling Mr. Kearney before he was indicted.
But when?
In 2023, July of 2023. We have documented evidence of her, the intimidated and emotionally harmed witness, contacting Mr. Kearney on social media and alluding to the fact, I know where you are, which is exactly what we're talking about with Gaetani.
That's a fair point to cross-examine her on, no doubt.
Don't know what she's going to say. From our perspective, having seen some of her other testimony and other proceedings, we don't just assume that she's going to be forthright. And we have a right, she's the star witness of this case.
I may need to know a little bit more about that. In terms of, if you want to file something and pound it to me, that's fine.
The final point I'll make, to Your Honor, before you have any other questions, is it's important that we're raising this now. This is well before trial. The prosecution is clearly on notice. I don't know where this may lead to, what else could be discovered. You know, this is a unique case, as you've noted, and evidence is discovered in all kinds of odd ways, believe me, with how these cases proceed and who shares what and those kinds of things. It's critical for us to make this record now, alert the court, especially if it comes up later after a jury is impaneled, there is a risk of a mistrial, and that will not be our fault, and we think at that point...
Listen, Ms. Bitter, I have no issue with you bringing the motion. You need to advocate for your clients in any way you think is appropriate. I'm just trying to flesh it out here so I understand exactly what the issues are. I'm struggling with the relevance issues. You may have to give me more information on that so I understand it a little bit better, because the way I read things, they're much later in time. Now, if you've got something that's more contemporaneous to the alleged intimidation, I think that's very, very relevant. And we'd have to sort of play out how that would come in and what the form of that evidence. So we'll come back to that at some point when you're ready to talk to me about that. But talk to me about this. Your motion had 3 parts. Your affidavit had 3 parts. And one was the 2024. That's moved because it's already been done. The second was this issue. The third was this idea that I could preclude the executive branch from investigating things in 2025. Can you give me some authority which says I have the ability to do that?
It's a unique situation, Your Honor. I'm not going to sit here and tell you that there is a case law roadmap to what's happening, but what's important to recognize here, you know, you've been asking us these questions about how is Gaetani relevant. She is extraordinarily relevant to what we're calling the 2025 investigation, which results in these search warrants for the phones of Karen Reed.
Which is still pending with Judge Krupp.
Right.
Let me play that out two ways. What if Judge Krupp says he can have access to the phones? Then we're going to have a much longer issue, correct? Is that going to come into this case?
Well, they're telling us that two people are under investigation. I mean, it's hard for us to know, right? I mean, they're attempting allegedly to indict Mr. Kearney and Karen Reed for actions in which they already tried to indict and a grand jury said no, and now 2 years later with phones that have been gathering dust, we need to look in these phones and, you know, God knows what we'll find. But the point is, the search warrants in that case are critical and certainly could relate to evidence used against Mr. Kearney. There are two informants in that search warrant. One of them is Lindsay Gaetani, and the affiant of that warrant is Detective Tully. And there are about 10 paragraphs, and I'm paraphrasing, I don't know the exact number.
I read the warrants.
Relying on her, and it is loaded with information which she provided them, and we're back to the personal interest of Mr. Cosgrove. So that really was meant to just inform the court that this is a living, breathing issue.
I will agree with you that it's a living, breathing issue. It's just not a living, breathing issue over which I have authority.
Fair enough.
When that comes to me, if it comes to me, I don't know if my special assignment encompasses that. We'll see. But if it comes to me, then we'll deal with that issue. I can find nothing which gives me the authority to restrict that activity. Judge Krupp has the authority on the search warrants, and he'll make a decision in due time. But I find nothing which gives me the authority to restrict prospectively an investigation that's being done by the executive branch.
Judge, just before I sit down, and unless the court has any other questions, I just want to correct one last thing. Your Honor had mentioned about a lawsuit being settled. That is not a lawsuit involving Mr. Cosgrove. There's no...
Sure it is. I looked at the docket this morning.
Not with him. That's with other parties to the litigation, is my understanding.
Well, let me play this out for you. It's, as I said, I have some familiarity with this immunity issue since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again, accusation is one thing, but it would seem like there's a little bit more. You'd have to have some substance to it to actually disqualify. But I'll keep an open mind on it.
Anything else?
No, I read all your stuff.
Thank you.
Anything more?
No, sir.
Mr. Braley, anything?
No, Judge, thank you.
Okay. Mr. Kearney, Mr. Cosgrove. If not, if you're conflicted out in one case, why aren't you conflicted out on the other? That's the real big question here.
Well, I don't think the two necessarily follow, Your Honor. Obviously, before I filed my motion seeking to withdraw in the other case, I would have been a poor attorney indeed if I didn't think about whether it also required me to withdraw in this case. And the motion to withdraw was, at least I attempted to phrase it quite carefully, to say that I had a conflict because Ms. Gaetani was the alleged victim in that case. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts. But nevertheless, it was essentially an argument that I would be making in that case that Mr. Kearney committed crimes against Ms. Gaetani. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Gaetani's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if it came to trial.
Well, that's a very interesting point, Your Honor. There's a couple of problems with it. One problem is the practical matter. I don't see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt the defense theory that everything is relevant to every issue, but I don't see how indicating that Ms. Kearney was not credible in making statements about the investigation of Mr. Kearney here would have any relevance to an accusation that I breached some sort of duty to her by turning over a police report, which is the contention. Also, Your Honor, assuming that this even survives a motion to dismiss, and I'm talking now about the Middlesex case, I don't think there's any factual dispute.
Worcester case, there's nothing in Middlesex, right?
I'm sorry, Worcester, yes,
Okay,
thank you,
all right.
I appreciate the correction. I don't think there's any factual dispute as to what happened. In my capacity as a prosecutor, I provided Mr. Bradel with the police report in question as discovery. It made its way by whatever means from Mr. Bradel to Mr. Kearney, who then publicized details of it and turned it over to a friend, an associate, whatever you want to call him, who actually put the whole report, as I understand it, on the internet and began pillaring Ms. Kearney over her credibility. I don't dispute that I turned that report over as a matter of discovery. If this case ever develops in Middlesex and comes to fruition, I couldn't possibly dispute that. That's the absolute factual truth. From that point on, it becomes a pure question of law as to whether I breached some sort of duty under the statute to Ms. Kearney under the mistaken belief that I had a Rule 14 obligation to turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias. Maybe I made a mistake. Maybe I was wrong legally. But that's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter...
How do we avoid the circumstance that she's called to the stand and there's some relevant testimony that she can offer? You wouldn't call her, but the defense calls her. And you're in the midst of cross-examining her and she says, well, this is why I sued you. What do we do with that?
I'm not sure what you do with it, Your Honor. Maybe we deal with that with a motion in limine to preclude her from mentioning the Middlesex suit.
Doesn't sound like a terribly controllable witness.
Well, that's why we have skillful Superior Court judges, Your Honor, if I could
If you can find one.
be a little obviously self-serving in my comment. I'm sure Your Honor, both in his prior career, as I have in mine, and in your present position, has dealt with witnesses that are difficult to control.
What about the possibility of someone else coming in? Is that something that's realistic or not realistic?
I didn't quite hear you. Something else?
What about the possibility of bringing someone in to deal with Ms. Gaetano if indeed she's a witness?
Could be done.
Well, it would solve a lot of issues. Right, Mr. Benro? I mean, you're not contending that the case goes away completely. You're contending that he can't deal with Gaetano.
Unless, Your Honor, I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani, but if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard-pressed to figure out why the issue of the lawsuit would come out.
It could. I don't know.
But that is my job to control what comes out. But so
Yes.
Legally, let's think about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think we all agree.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure it out. I guess the first question is, why are we having this conversation, and why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we're having this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove...
I think he's not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. So it would appear to me what you're saying to me is, if there was a replacement for that issue, that would resolve this problem.
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility of Ms. Gaetani.
You'd agree with me that does happen in trials, not with some frequency, but it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a statement of a defendant. They have to be a witness. These kinds of things can happen all the time.
We find ways around them.
But we're also, to be clear, we're dealing with a very rare situation where the witness is a former prosecution witness accusing the prosecutor who she testified for previously of misconduct. Now, if the prosecution and the court approves of that process, wants to have that laid bare, then I suppose it could. But the other problem, just
on this issue, we're not going to hijack the rest of the argument.
Okay,
just on the issue of replacement.
I had a brief response.
Yeah, he's not done. You only get to respond when he's done.
Yes.
Mr. Cosgrove.
Well, just on that point, I had yet to hear how any comment that I might make on the credibility of Ms. Gaetani's testimony in the case before the court would even come in or be relevant in the Middlesex case or assist me in any way. I'm going to go over to Middlesex Superior Court, and, frankly, I find it hard to believe that I or whoever would be representing me would be brazen enough to say to the judge, well, I want to talk about all the ways in which my client, Mr. Cosgrove, impeached Ms. Gaetani in a case that has nothing whatsoever to do with the case before the court. There's just not going to be any bleed through whatsoever, it seems to me. We don't even have, frankly, Ms. Gaetani's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that either the Commonwealth or the defense is going to call her in this case. Mr. Counsel has carefully said we may call her for the defense. This may be a contingency that doesn't even arise, but that's sort of a side point. Let me just take a couple of points. I was going to ask Your Honor to take judicial notice of the pleadings in the Middlesex case and the docket. It appears you've effectively done that, but let me make an oral motion on the record.
Any objection comes?
No. Purpose.
Okay. By agreement, I'll take those as judicial notice as to the Worcester Superior Court case.
And one of the interesting, unique things about this alleged conflict of interest, which is a little different from the typical conflict of interest case, at least I haven't found anything precisely on point, and I don't think the defense has either, but maybe they'll prove me wrong in a moment, is the whole operation by which this alleged conflict has come about and the Middlesex case has come about. What is it that enables Ms. Kearney to make the claim that she's seeking to make against me in the Middlesex case? It's that the defendant took the report I gave him as discovery, or I gave his counsel as discovery in the other case, publicized it, and then created a harm that Ms. Kearney alleges accrued to her from that publication. In other words, if we're applying but-for causation, to sound like a tort lawyer for a minute, if we take Mr. Kearney's actions out of the whole proceeding, there's no harm whatsoever to Ms. Kearney with my, as I see it, fulfilling my Rule 14 obligation. So Your Honor has the unusual situation here of a defendant who has been but-for cause of the alleged conflict, seeking to profit from that conflict by removing the prosecutor of his case, which I think is worth some consideration by the court. What I would like to do now, Your Honor, since the defendant has had the opportunity for a reply brief, which frankly doesn't particularly go to these motions, particularly, but more to the point, the defendant's reply in support of the motion to disqualify Robert Cosgrove. I'd like to examine that in some detail and take the opportunity to reply to some of his.
Well, it really hasn't become an issue here. That involves another party whose case has been dismissed. The case regarding the defendant and that witness is gone. That's dismissed. So I don't really know if that's all that relevant to any. Ms. Miller didn't even raise it.
For purposes of this, Your Honor, the briefs are what they are. We submitted them. I just raised the issues I thought would be helpful for the court today.
Yeah, I didn't find that anything with regard to that particular trooper terribly compelling because I don't understand how he would be part of this case. Fair to say?
You're talking about which trooper?
The trooper whose case was dismissed, Bouchard.
I'm not talking about the. I'm sorry for interrupting, Your Honor. I'm not talking about the motion that they filed with respect to discovery for Mr. Proctor.
Oh, I'm not dealing with discovery right now. Yeah.
I'm talking about the motion that's captioned, "Sir, reply in support of motion to disqualify Robert Cosgrove."
Paper 127 you're talking about.
I don't know the number, to be honest with you, but
This one here?
yes, exactly.
Yeah, that's 127.
Okay.
Okay, go on, I'll hear you.
All right. So, the defense begins by complaining that my response envisions my conflict in a vacuum, and that it ignores the whole context, which is basically a preface, Your Honor, for talking about everything else that the defense is unhappy with about the case, except issues that are relevant to whether or not I should be disqualified. There is, on page 1 of that motion, suggestion that Mr. Morrissey recused his office from prosecuting Mr. Kearney due to a conflict created by an investigating journalist who publicly accused the DA's office. I'm not sure that Mr. Morrissey has made a statement explaining why he appointed a special prosecutor, but I'm ready to stand to be corrected, but certainly this is the explanation that might sound most favorable to the defendant. But what does it have to do with disqualifying me? He then talks about accusations against Lieutenant Tully and former Trooper Proctor and Sergeant Uri Buchanan. What does that have to do with disqualifying me? He talks about actions by Sergeant Buchanan taken after he left the Norfolk District Attorney's office in support of a legal civil dispute between Ms. Reed and the alleged victims. In this case, that has nothing to do with whether I should be disqualified. We've talked about my voluntary withdrawal from the indictments concerning Ms. Gattani. And if Your Honor would take a look at page 6, where we have bullet points. All right? The first bullet point is absolutely relevant, and that's what we've talked about, that I'm being sued for intentional misconduct by Ms. Gattani. Then we hear that Lieutenant Tully is being sued by Ms. Gattani. So what? That Detective Tully has been sued by Karen Reed. What's that got to do with the price of beans, as they say? That there were disciplinary proceedings against Lieutenant Tully.
That might be relevant on cross, you'd agree?
Oh, yeah, it might have some relevance on cross, but what has it to do with disqualifying me, Your Honor? They weren't disciplinary proceedings
Fair point.
against me. We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed, but what has it to do with disqualifying me in this case? We hear that Buchanan was disciplined. That Proctor has been sued by Ms. Reed. That Proctor has had disparaging text about Ms. Reed. There are two things that the upcoming case should not be about, Your Honor, and I'm sorry I'm losing my voice here, excuse me. One, it should not be a trial of the case that has been null pros concerning Ms. Gattani. And two, it should not be a retrial of the Karen Reed case. None of this stuff is relevant. Gattani's testimony will undermine the credibility of Detective Lieutenant Tully and Ms. McCabe, which will subject her to cross-examination by Mr. Cosgrove. Now, let's look specifically, if I can skip ahead in the memorandum. The argument that's been made a little later on in the memorandum, in which Your Honor has heard again today. And I'm looking now at page 16, Your Honor, the first full paragraph. Ms. Gattani will testify that Detective Lieutenant Tully intentionally mishandled her cell phone by tampering with and or deleting its contents. Detective Lieutenant Tully will deny this. Mr. Cosgrove has accepted Detective Lieutenant Tully's explanation without any further investigation. Well, I don't know how the defense knows that I've accepted Detective Lieutenant Tully's explanation without any further investigation. But let's put this on a timeline. it has been the contention of the defense from the start of the case that certain items were missing from the download of Ms. Gattani's cell phone. And their explanation is that must be because Detective Lieutenant Tully deleted it. I responded to that. Ms. Kearney is a latecomer to this discussion. She is only now, in the form of either public statements or representations by the defense as to her new position, suggested that this is because Detective Lieutenant Tully hampered with it or deleted its contents. By the way, I don't know how she would know that because she was not there during the download of her cell phone and the transfer of it. But at any rate, my response as to what happened to the cell phone occurred before Ms. Kearney made any of these statements whatsoever. I don't know how it can be that I have been siding with Detective Lieutenant Tully over Ms. Gattani. I haven't seen an affidavit from Ms. Gattani. I haven't seen anything from Ms. Gattani other than hearsay, which is just a representation. And certainly, but let's assume that I do, as they put it, side with Detective Lieutenant Tully in cross-examining Ms. Kearney and in the closing argument. What does that have to do with defending my position in the Middlesex case, and how is it relevant, and how would it even be introduced? I have no idea. Let me back up and make a couple of other points. I want to turn to the legal argument, say a little bit about the law, and I suspect Your Honor has probably already looked at the two cases cited by Mr. Betterow, Commonwealth versus Dunlap, and the other case is named U.S. v. Health, which involves a complicated civil action involving the Church of Scientology and others. The first thing to say about these cases is they're Pennsylvania cases, not Massachusetts cases. So at best, I would say they are persuasive authority, not binding authority.
I don't think Ms. Betterow contends otherwise.
The second thing I would say is that they are both opinions in which the court declined to rule for the defense on the conflict of interest argument. In the first case, Dunlap, the decision of the Superior Court judge was affirmed by an equally divided court. The dissenting justices characterized the other side as the majority, but the opinion itself says that the appellate court was equally divided. So I'm not sure if it's even good as dicta. It seems to me it has no precedential value at all, but if it does have precedential value, it was a ruling in favor of the Commonwealth. And what were the facts? In a sentence from the dissent, that is, those who believe there was a conflict of interest, the district attorney who prosecuted this case also represented the victim in a civil suit arising out of the same transaction. That is a mile away. That is a stadium away. That is a continent away from the facts in this case. I am certainly not representing Ms. Gattani in a civil suit arising out of the events that bring the defendant into court. Now let's take a look at U.S. v. Health or Health, I guess it is, which is the federal case. That does have some interesting parallels to this case. According to the decision, and I apologize for not having the pin sites, but I think Your Honor will readily find them. The defendants contended on appeal that they were denied due process because two prosecutors were defendants in a civil action filed by the Church of Scientology 10 days after the events that went down in this particular case. And they alleged, and the events that went down were a search of the Scientology's office in Los Angeles, and they alleged that the raids were conducted in bad faith with the intention of violating Scientology's constitutional rights. You can look back at the memos filed by the defense and the contention they're trying to make. But one of them is that this is a bad faith prosecution. So that applies here. What is different here is the civil suit apparently precedes the raid that the prosecutors make in the defense office in the Church of Scientology. Here, there's nothing like that. The events that the defendant was charged with in this case occur before any involvement by Ms. Gattani, before any involvement, by that matter, with me. And those issues are pretty well set and have consistently been followed through. Now, here's another similarity between Height and the current case. I'll just read a sentence or two. The government contends that prosecutors cannot be disqualified when sued by a defendant because defendants could then remove whichever prosecutor they please simply by suing him. Now, of course, the defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential conflict. I have not gone so far as to represent to the court that I cannot be disqualified when sued by a defendant or by Ms. Gattani. I think in fairness, the court can look at it. But the federal court, the argument was that any suit complaining of an action taken in the prosecutor's quasi-judicial capacity would be frivolous and non-disqualifying because he enjoys absolute immunity as a prosecutor. Cite to a U.S. Supreme Court case. I believe as Your Honor reads through, we'll find that the court in Height pretty much bought that argument. And they go on to say that appellants have made no credible claim of actual prejudice based on the prosecutor's alleged pecuniary or personal interest in the outcome of this prosecution. I certainly have no pecuniary interest in the outcome of this prosecution. I have no personal interest in the outcome of this prosecution. And nothing in this prosecution is going to affect anything that's going on in Middlesex. In Worcester Superior Court, Your Honor.
Understood. Anything further? From Mr. Cosgrove.
Sorry. No, I'll stop at that point, Your Honor.
Mr. Bedero.
Yes, thank you, Your Honor. We might as well start from the back with U.S. v. Health, Your Honor, which is 668 Federal 2nd, 1238, D.C. Circuit, 1981. Mr. Cosgrove has buried the lead about health and about Dunlop. Those were appellate arguments post-conviction. Now, that is a huge distinction about a timely motion in advance, raising issues which could lead to a conflict. We all know that raising a conflict on appeal, when you could have raised it before, is looked at in an entirely different way. And the relevant language from health that I would direct the court to is on page 1276, which states, given the need to promote the appearance of justice, a trial court on timely motion, to wit, like here, should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. That's here.
Well, the key words there are alleging bad faith. I'm not sure that there's an allegation in those other complaints of bad faith. There's an allegation he violated the statute. I'm not sure where it talks about bad faith.
Sued him for intentional infliction of emotional distress, coercion.
Negligent infliction, there's a difference.
She sued for intentional.
I read negligent, but I'll
Respectfully, Your Honor, there are deliberate allegations of intentional misconduct in the complaint, but the court can obviously go back and one of us.
We took judicial notice.
Exactly. One of us is right.
I read this morning as negligent, but I could.
Dunlop is the same situation, Your Honor. It's post-conviction. The other issue, and I want to go back to the beginning that Mr. Cosgrove started with, he illustrates the whole problem here. He's defending himself, and I have no opinion on the merits of Ms. Gaetani's claim, okay? As a lawyer, I sympathize. But he started by telling you that this case is going to get dismissed, and all I did was turn over this. He is illustrating front and center his personal interest, that Gaetani is accusing him of things he didn't do. And the conflict, the personal interest, isn't the outcome.
He's not accusing things he didn't do. He acknowledges doing it.
But he's justifying it and saying she's trying to do this, she's not credible. The point is this: the personal interest for Mr. Cosgrove is not whether he was wrongfully sued or whether it has any merit. His good name has been attacked. And like anyone else, he has an absolute right and a personal interest in defending himself. And again, the proper forum to do that is not while prosecuting a case in which his accuser is a witness, his co-defendant is a witness, and Ms. Gaetani is going to probably impeach, assuming she's allowed to, their star witness, Ms. McCabe. When someone's integrity is attacked, they have a personal interest, especially someone as credentialed and respected as Mr. Cosgrove. We all understand that as lawyers and judges, but that doesn't mean you get to prosecute the case. That's for you to decide, obviously. And we're talking about an appearance. If this looks terrible, which leads to my next point. Mr. Cosgrove went through all of these allegations in our papers about, Proctor had this, Tully's been sanctioned, Buchanan, it's literally aligned with Jennifer McCabe, which we wrote about, supporting her. Buchanan was a witness in this case too, and part of the investigation.
But not anymore.
No, but the point is this: he is looking at this in a vacuum. The public must have confidence. Part of the analysis of a conflict of interest is the first sentence of the brief that he just cited from, is that the public must have confidence in the criminal justice system. And this latest conflict is a pile on conflict after conflict after conflict in this case. And if the cherry on the sundae...
But let me slow you down, because we're conflating two different issues. I'll agree with you. There's all sorts of issues that have developed over the course of these interrelated prosecutions. Mr. Cosgrove's role, though, was a latecomer and really had nothing to do with any of these other issues. So I can't sit and say I impute all of those other things to Mr. Cosgrove. And therefore, if we look at that mass of problems that have developed, he's out. Because the same logic would say the next person who sits in that seat, the same argument would apply.
Let me be very clear. I'm not accusing...
I didn't take it that you were.
Fair enough.
But my point is, all of those things are conditions which are already present in this prosecution.
They are.
So really the only thing that I'm dealing with is this one issue, because the rest of those things he had nothing to do with.
Well, one of them, he had this other conflict which he voluntarily sought.
But that came out of the same exact issue.
Yes, well, that's our point. We think it's the same conflict.
I agree with you. But what I'm trying to, the point I'm trying to draw and the distinction is, all of these other problems that arose out of the Reed prosecution, real, imagined, substantial, that's really not for me to decide, right? They're all out there, all right? And they're all going to be there no matter what. So whoever sits in that chair right there is going to have all those problems.
The difference, I didn't mean to cut you off, Your Honor.
Yeah.
The difference is that if it's not Mr. Cosgrove, the man or woman who would be sitting in that chair is not being sued by Ms. Gaetani and co-defendants with DL policy.
That's my point. That's the only thing I have to analyze.
Okay.
That point.
Our point respectfully was that given the public's need for confidence, in this case, not the Kearney case, that's a whole nother conversation for someone else on another day. But this case is filled with conflicts, and I don't think we can all just avert our eyes to and say, but none of that matters, but we're going to have a prosecutor now cross-examine his accuser and then say she's not credible. He also indicated, Your Honor, they're not even calling Ms. Gaetani. I can't fathom how that might happen. They use careful language. They may call her. We're the defense. We don't have to do anything. We can take a nap throughout this trial.
Understood.
And there may be such a terrible joke of a case they present that we stand up and rest. So, of course, why would any credible, serious lawyer commit a year in advance, I'm calling this witness? We're alerting Mr. Cosgrove to what we think is his conflict and the court, and we may very well do that. The last point for this, he said there's no affidavit from Ms. Gaetani, or it's all just hearsay about, tampering with her phone. The best basis for that will be the posting online social media by a third party and long-time known critic of Mr. Kearney of messages which did not appear on an extraction report that we got from Tully of Gaetani's phone, and then we never got anything from Tully's phone. We got screenshots of what he claimed were messages. That's the basis for that. Thank you.
Okay, fair enough. All right, so here's what we'll do. We're going to set another date. Let me talk about this. Mr. Braden, when we we penciled in the trial date, I gave you a very long date, longer than I wanted. Your schedule, has it changed? Can we get this thing done earlier? Assuming it's alive?
Judge, it's probably gotten worse.
All right, well, we're not moving the case back. That trial date's not going to go backwards.
Okay.
This is a 2023 case, it's 2026. It's not going backwards. If anything, it's going to move forward, so don't.
I know you'll relate to this, Judge. I have the usual
I know.
slate of like fall murder cases.
I get it, but this one's an old one, and it's set, so I was gonna try to move you forward, but if you tell me that can't happen, then that can't happen.
I'm sorry.
All right, but understood, this court is willing to take this case much faster than the current schedule.
Your Honor. We do have a few other pretrial matters to address. Your Honor mentioned the motion to dismiss. Maybe we should schedule that.
What we're gonna do is this. I'm gonna take this under advisement. We're gonna pick a date right now. And either we do a motion to dismiss that day, or we're on for appearance of new counsel that day. All right, one or the other. We're gonna know. I'll get your decision beforehand. Now, I am open to the idea that if I accept there's a conflict here, I haven't made that determination yet, but if I accept there's a conflict, I'm open to the idea that it's resolvable by having someone else step in and cross-examine her. I think that solves all of the issues. So that might be the easy way here, so everybody can get this thing moving and have this trial, which all parties seem to desire.
So just on that point, I appreciate you kind of reflecting your thought process. But, even if counsel stays on the case, but doesn't actually do the questioning, it still remains that there's a conflicted counsel on the case, and the jury ought to know
you and I both know
that
that
interest.
Mr. Brett, you and I both know this happens with some frequency, and we work our way around it. all right? The jury's concentration in this case is on the events of the case. Now, Ms. McCabe's credibility, I expect to be a robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But Mr. Cosgrove raises a reasonably good point that, you know, there's been some recent case law talking about, you know, the police can't create their own exigency. And to some extent, the defendant has created his own exigency here. Because, in fact, the plaintiff in that case, is suing because the contents of her phone were put on the internet. The defendant did that. So there is some, you know, you got to be fair to both sides here and say this is something which only happened because of steps taken by the defendant.
Well, Judge, I don't want our lack of response to that to be perceived as a acknowledgement. I don't want to address that.
I'm basing that simply on what I read in her complaint. Not anything that's been represented to me today.
Right, exactly. And so, just a couple rewinds here, judges, that the government themselves, in Lieutenant Tully's own affidavit, at the time of this, back in December of 23, swore in the affidavit that Ms. Kearney was a witness in the matter. And so I don't think the government can do a 180 and say, oh, she's not really a witness.
Well, she's a witness, but she was a witness at that point. They were trying to indict your client for some sort of conspiracy charge, which failed.
Right.
All right, and
the
grand jury didn't
live and under investigation.
Well, that's another matter. I've told you I have no authority to affect that. What I do know is that was no build.
No build.
Even worse. Okay, that was no build. So I can't imagine a circumstance where I would allow evidence in about a no build issue. I remain to be persuaded on that.
So what? And just to go to the lowest hanging fruit on why Ms. Kearney would be a witness, there's all sorts of screenshots and text messages, and we need these things authenticated before we use them.
I'm not necessarily saying that can't happen.
There's all sorts of reasons.
I get that, but
no one's trying to trigger a recusal. There's a lot of good reasons why she's involved in this. The government's own affidavit.
I'm not discrediting what you're saying. What I'm saying to you is, I think there's a way around this. And I don't know that a closing argument is going to change that, because the closing argument is based on what's heard at the trial, and I'd add, in this court's view, and in the proper practice, would be confined strictly to the evidence that's presented before the court. So, no, it's not going to.
I appreciate your reflections, Judge. If I could just have one moment.
Yeah.
Thank you very much. All right, that's all we have. And just,
Let's pick a date.
are you, late February, March, okay? Early March? What would you like, Your Honor?
Let's go later in March.
All right, March 27th?
Is that a Friday? Fridays are generally best.
I can do that.
It is a Friday.
Do it on a Friday.
Thank you.
I don't know if we'll be in this room. I'll have to consult with the occupant, who has generously lent me this room today.
I want to say one other thing, if I could,
Sure.
Your Honor. I am concerned that the protective orders that have been issued by the court have been the subject of violations. I'm not prepared to address it today, but I want to put the defense and the court on notice that I do think there's a basis for that argument, and I will plan on raising it at the next hearing.
Well, raise it first with the other side, so that they're aware of your concerns.
I will, of course.
All right. If it's not resolvable, then the court will step in. Nobody benefits by undermining the protective orders. Look, again, the way this court looks at this, is that this is an important First Amendment issue which should be decided by a jury of the defendant's peers to decide the mores of our society, whether or not this is journalistic activity or it's not journalistic activity. Let's try to focus on that, folks.
I absolutely agree with that, Your Honor.
Okay? All right. Anything else we can do today?
No, sir.
March 27th, the purpose of that hearing to be determined, but could be one of those two things.
Thank you.
Thank
Okay?
you very much, Your Honor.
All right.
Your Honor.
Great, both matters continued to March 27th, time and session.
Court, all right, please. Yeah, the courtroom at the time, please. Thank you.
Free Turtle Boy, free Turtle Boy, free Turtle Boy.
That is exactly why the judge does not want to do Zoom. Do you know what I mean? Use your fucking login, you twat. So the judge said at the start, so I'm gonna have to put this into members only or something, because he says you can't replay unless you're part of the media, and I'm not part of the media. It's just, this is why I don't like to cover these hearings, because it's like Groundhog Day. We just go on to another one now, another hearing. Nothing gets resolved. The only thing that happens is Aidan gets another bill. Bedro wishes it time to come up to Boston. The Cosgrove gets paid even more money that the people have to pay for, not the Commonwealth. The money's coming from the people, so it's from the taxes. Nothing gets resolved. It's so frustrating. They're trying to minimise what Gemma McCabe's role in all this. I think most people have seen some of the tweets, the screenshots of her definitely not being intimidated by Aidan. And yeah. But by all accounts, this judge does not want to do any more Zooms. So he said at the beginning of this that he's accommodating Zoom today, but it looks like he won't be doing them in the future. Maybe I got that wrong, but that's how I interpret it as, and he does not want this to be restreamed and stuff like that. Obviously, I'm not going to take it down. I can't. My sound is at maximum, I believe, Terry. Excuse me. I don't think it's my sound. I can go up a little bit more, but not much more, unless it's my settings. Is anyone else having difficulties? But it is infuriating, because can you imagine the cost? Like, Aidan has to pay for Mark to come up here every time. He has to give up his time as well. Brady has to give up his time, and nothing gets resolved. Obviously, they're going to discuss the motion to dismiss in the next one, but I thought they were going to do a lot more this time, but they didn't. Judge seems to be quite pissed. Cosgrove is definitely pissed about Aidan sharing stuff online, but he's not the one that posted them, so he's just sharing them. I got you on full, but can hear you fine. Happy days. Do you say you're done streaming for the day, or I heard you? I will be done streaming. Yes, I will be done streaming. In a little bit. Just a little bit. I'm going to stay on for another half hour or so, just to see what's happening in the world, see what the world of Twitter is bringing on us. Bear with me whilst I take that over. These hearings, I just hate them because they do not resolve anything. And headphones on. Can you bump your mic? My mics are full. My mics are full. Hang on, let me change my mic then. Hang on. Hang on. Performance mode. Oh, for fuck's sake! I don't know what that is. I don't know what that is. Yeah, I'm not. Yeah, Erica. Everyone can go and watch Erica. I'm not. Oh shit! I don't know what happened. Where have I gone? Right. Let me try these now. Properties. Let me try this. Road. This is road. Hello, hello. That's as loud as I can go. Fuck's sakes. Okay, can you hear me now? I don't know why I was muted. I don't know why that was muted. Right. I agree, Carol. The Commonwealth know what they're doing because this is literally costing a lot of money, not just for Aidan, but for the taxpayers. You know, everyone should be up in arms about this. People in the state are paying for that Cosgrove. Jeepers, he talks so slow. It's unbelievable. Oh, you can hear me. Happy days. Yeah, my volume though, my volume is at max. I'm afraid to say to people, I can't get it louder than that. I'm afraid. So I don't know what else to do with that. Thank you as well to Jacqueline Wilkins for subscribing. Thank you for subscribing, Jacqueline. You did that an hour ago, but I didn't have a chance to say thank you until now. And then Karen, you did ask, has J. Crub ruled on Karen's phone yet? No, is the answer that we just found out. Supper is egg mayonnaise sandwich. Egg mayonnaise sandwich, my darling. Right, hang on. Let me see if there's any action. Oh, let me see if Erica's gone. No, Erica's not live. I will see. Oh, thank you, Badazza, for sharing. I didn't realize until just now that you'd shared the stream. Thank you, Badazza. Yeah, I know, Josie. It's unbelievable, isn't it? Right, hang on. It's a mess out there. Oops. I wasn't planning on going live. This is why I'm a little bit thing. Oh, this is Erica is live, people. She is live. She's just gone live. Oh, she's just gone live and then gone off again. So she went live and then she went off again. So she will be going live in a second. Once I get a link, I'll kick you over. I'll still stay on. I'm not going to stream her. Go support her. It's the first day of streaming properly on the stream today. So make sure you do support her, subscribe to her, like her videos and stuff like that. I don't know why she made me a mod, because I will hardly be ever on the channel, but I'll always support her. I'm going to stay on for a little bit longer, but once she goes live again, I will post the link for you all to go over there and watch that. So, Boomer Besties. We got questions is the channel. We got questions is the channel, Rhonda. Channel is, that's her channel. We got questions. I think she will go live because obviously she'll probably interview Aidan on the way out. I'm not going to stream Sniper. I'd rather everyone go over there and leave me and watch it. But I'll stay on for a little bit longer to see. Because I was not planning on doing any of this today with Aidan's. Because I knew what it was going to be like. But then I thought, you know what, I will do it. So, right. Oh, I need to take that. This is, so if you've not noticed, this is a new stream layout. So it's still new to me. And that's why I'm fucking up all the time. This is no longer StreamYard. This is Streamlabs. So it's a mess. So you're going to have to bear with me as I try and play about with everything. So I can't bring chats on screen. I keep losing where the chats are. Give you some... KD, give you some notice. No worries, Rhonda. It's all good, my darling. Yeah, where is Dave? I've not seen Dave for ages. Oh, where is Dave? I'm a bit worried about Dave now. I've not seen him for a while. Right, can I even do a poll here? Let me check if I can do a poll. We've not seen Dave for a few days now. Okay, start. Question is, do you like this judge? Oh shit. Because I don't. I'm all for a judge being I'm all for a judge being engaging and stuff, but it just seemed like he just didn't want to. He'd already made his mind up. He literally did not care about hearing what Mark Bedrow had to say. You know, there's a lot of stuff that judges can do, and I like the engagement going back and forward, but it just doesn't feel like we achieve anything. And by the sounds of it, he's going to rule that, you know, they can add someone in to do some crosses and stuff. It's just, they're just pushing the can down the road again. And I don't get it. I don't understand it. Another hearing on March 27th. And you know what's going to happen. He's not going to dismiss the case. He's very keen to get this case on. Obviously, Bradel can't do this case sooner, by all accounts. So I believe, is it 1st of December the case is scheduled for? Or something around there anyway. So it seems that we're going to be leaving, not changing that. Thank you, Yaya. I appreciate that, Yaya Trucker. Enjoying the company here. It's, as I say, I'm just a bit of a boomer today and yesterday. If you saw my members only yesterday, you'd understand it was very boomer-tastic. And today is the same. I just feel sad that the courts can actually do this kind of stuff. I just feel, I don't know. It should and could be a lot quicker. 2023 and we're now at 2026. I think a lot of the other judges could have stepped in well before now. So I don't think it's a criticism on the defense for not able to do it sooner. I think the state of Massachusetts should have done this sooner, and I think that no charges should have been brought forward in the first place for this. Carol says he made it very clear he wants to go to trial. He's not going to dismiss the judge, the case. Yeah, no, your charges. Yeah, he's not going to dismiss them. It seems to be this thing about wanting to set an example and stuff, and we all know that Aidan's case is going to set an example. That's why it's so imperative to support it, because whatever happens here will, that will create the landscape in the future. Josie said, I think if it goes to trial, it won't be good. Aidan is very harsh. Love him or hate him, he does come across aggressive. He shouldn't be judged on that, but we know how people are. And that's why the jury, you just need a good set of jury that can actually, basically people that have got common sense, that can understand what the First Amendment is. That's what you need. But you're right, that's why it shouldn't even go to trial. Today's the first day I have been able to be on YouTube during the day. Oh, there you go, Robin G. I thought you got missing for a while. Hope you're doing okay, my darling. To be fair, we've not really streamed all that much. Just some bullshit streams, to be honest with you. I agree. You just never know how a jury are going to react to anything. So even though we know that this is all bullshit, you still know that anything in the hands of a jury is dangerous, especially when it's bullshit. We had this with the what's his name, Adrian Gonzalez one, where I just believe that judges should earn their money and make decisions. Unfortunately, they're not willing to make decisions. They're not willing to do what they're getting paid for. I think it might be a god complex for some of them, and also a lot of them just like the attention. So I don't know if this guy's going to let it all be streamed or not. I really don't know if he's going to allow this trial to be streamed. He was very much about basically saying that we're very lucky that he even let us have Zoom today. Which is why I'm pissed off with that guy saying free Tailboy, free. That just gives the judge another reason not to allow us to stream. So sometimes just, I haven't got a song here, but the song goes, shut the fuck up. Katie says, I still think it's wrong, even, oops, I'm looking at the screen, I should look at the chat. I still think it's odd Cosgrove doesn't even know if he's going to call Tully as a witness. Like, what the fuck? Just fucking odd. Whole case is just done. Yeah, I mean, they'll put Tully down, but they don't know if they're going to call him. They'll put loads of people. If you look at it, there was a trial we saw recently, and there was like 165 witnesses, and they called like 30. They put people down because the defense then have to research on all these. You mark my words. When it goes to trial, Cosgrove will have half of Norfolk County on his witness list just to piss the defense off. And then they will have to speak to everyone and cross everybody and stuff like that. Hopefully they will get a live camera in there. Hopefully they might do a pool. So what they might do is a pool camera and not have Zoom anymore. So I'm not saying that you won't allow live recording. You just won't allow live Zooms, is my gathering of what he's saying. I bet they just want to... Oh, I hope you and Mace are doing well, Erin. Yes, sorry. I bet they just want to play videos of Aidan saying cunt 500 times and call it a day. Yes. Because you know what people like. Some people don't like the word. And because of that, they will not like that it's a bit slow. No, not that one. You see, now I'm not on stream. I haven't got all functionalities that I used to have. Let's see if this works.
You're a cunt. You're a cunt.
Hang on. Let me do this then. Hang on. Here it is for anyone that's not seen it.
You're a cunt.
You're a cunt.
You're a cunt. You're a cunt.
You're a cunt.
You're a cunt.
You're a cunt.
You're a cunt.
That's and most people don't like that word, you know, and it's got different meanings, different place. In some parts of Wales, if you call someone a cunt, it's your best mate type of thing. So, but yeah, I can't imagine that going down well with the jury. Some people. See you later, Robin. People that don't want to hear that word as most likely that word. Yes, true. Fact. And people that don't understand what the First Amendment is and what rights you have as people to do and say and all that, you know. It all depends. It's infuriating. Boya kashamake, sweet child of mine. So yeah, it is frustrating. But there were times today that this judge, that Cosgrove, I literally, if I could unmute myself, I would have, right? Oh shit, that's gone wrong. If I could unmute myself today when Cosgrove was speaking, I would have just played this to him and just been like, hey dude.
Hey man, just want to let you know that sometimes you gotta shut the fuck up. And this current time is just one of those times you gotta shut the fuck up.
Cosgrove, you got it?
I don't think you're a bad person, I just don't want to hear you talking anymore.
Cosgrove, you got it? You see? You gotta shut the fuck up sometimes. Unfortunately, a lot of these people like to just speak. That judge wasn't great, huh? No, it was not great. Somebody said in chat, and I don't know who said it, but somebody said that they are from Canton, which obviously is not great either. Considering their links, and you know, when you got McCabe and all them from Canton, I think if you got roots to Canton, that's a little bit. That's all I say is That is not always a good thing, is it? Especially when you just don't know, because people are frigging like we know. Look at that. What was her name? Judge Bev. Her. What was it? Her house. Some of the McCabe's or Alberts or something stayed in her house or something, or like, I don't get it. Cunton, I know it does. Yeah, that's what I'm gonna call it from now on. Cunton. So in Cunton, but yeah, just another day, people. Another bullshit hearing. Another day. We could just go wait till March 27th now, and see what happens next. I just wish I don't know what Cosgrove is going to bring up next time. But obviously we got the motion to dismiss, and he's also going to bring up about Aidan posting and sharing stuff on Twitter, on X. So yeah, I don't know. Anyway, as a reminder, people, I like the snow fairy. Beautiful smell. As a reminder, but right, I don't think there's much else for us to do or to talk about. Go and subscribe to my sister from another mister. She smashed it today. She had over 1,000 viewers today. So Erica did, and Dina. So support them. I imagine they'll be at every hearing, pre-hearing. So you can go and watch them. And they will, and also I know that Erica's going to go more live as well, so I'm sure there'll be some opinions based on that. So if you want to discuss some of these things, I'm sure that Erica will be doing shows for that as well in the future. You know that I'm not, as I say, I wasn't sure if I was going to stream this today, but I feel it's right to stream Aidan's hearings because any of us could be in his shoes. And even though I don't cover it vastly because of the other trials and stuff like that, it is one I'm going to cover. As I said to you previously, I don't believe I will be covering Karen's stuff anymore, but definitely Aidan's, because it's still important. He is facing prison, and again, what Josie said, it doesn't matter what you think of the guy, and I actually think it's alright. He did nothing wrong to me whatsoever, so but they get a new DA in November, so it may be dropped by then. That's true story as well. November is the new DA, and the trial is supposed to be in December 1st, I believe. So imagine that, new DA comes in and drops it. It could happen. Is it likely to happen? No. But it could happen. I hate when our time is up. Don't you get bored and just want to go live to chat? I do, but I also understand there's so many other channels that are live and discussing various things that I'm just like, do you know what? Also, I that's why I went live yesterday, so you guys could see me do the Streamlabs stuff. I would have normally done that behind closed doors, but I went live for a few hours just because I was like, well, you guys can watch me make a mess of this stream. Do you know what I mean? So that's why I went live. But there's so many other streams that are live as well now. So I have never been more excited to vote locally than I am this upcoming November. Have you got something, Erin Hack? Have you? In Minnesota. So is this? Sorry, I am a bit stupid. Only a bit though. Is it some? Is all like DA, district attorney elections in November for every state? Is there some sort of election on in November? This is how political I am. I don't understand anything. So is there some what? Yeah, is this a statewide thing that everyone has to employ new DAs or something? Considering Erin Hack is from Minnesota, I had you on the whole time. Just was unable to listen the whole time. No, you're all good. You're all good. Wicked. Governor. That's what, as we say, as they say in London. Oh, a governor. So Erin Hack is going to get a new governor. So it's not like. So there won't be like elections across the whole of America then. So Erica's on live now, is she? Okay, well there you go. I'll end the stream then, and everyone go over and see Erica then. I'll give you the I'll send you the link here now. Oh, she's not. I haven't got hers live. She's not on live for me. Nope, she's not on live for me. I don't know where she's live then, sorry. But she's not live on mine. Badaza. You see, Badaza brings the tone right down. There you go. Welcome to the alternate corner, where we discuss topics of all variety, and then the chat gets vulgar, but we wouldn't have it any other way. Right, everyone, have a great weekend. I'll be back Monday. I don't know what we're doing Monday yet, but we'll be back Monday. We'll do something. Oh, hang on. Before I go, shall I do an update on that other trial? Hang on. Oh, what's it called? What's the trial that we've been, the jury selection one? What's the frigging called? Yeah, I got Erica 3 hours ago, but not live now. What's the one we're covering? We got questions. Thank you, Kimmy. We're covering it. The one in Michigan. What's it called? We've been covering it for the last few days. Katie, come on. Yeah, what's it called? I don't remember what it's called. Oh, frig, I'm going to have to look now, aren't I? Dale Warner. Let me have a look here then. Dale Warner. Let me have a look, just in case there's an update. Just want to check there if there was an update. Okay, hang on. I'll play you this and then we'll end it. So, right, I'll play you this and we'll end it, people. Just in time for Robin to be back. Right, so this is it. This is about a minute long. No, or display capture, that's what it is.
3 trial update for the Dale Warner murder case. Just got out of court, did a quick noon live shot. Court is breaking for lunch, but I just want to give you some updated numbers and a few developments that happened today on day 3 of voir dire. So far, we've been through 20 potential jurors today, but it's not been very successful in moving many of them on to the next round. 14 have been dismissed, 4 of those because they are members of the Justice for D Facebook group. If you'll recall, that group is an advocacy group for Justice for D. It has 23,000 members in it. So we now can confirm that people are being excluded from potential juror duty simply because they are members of that group. I thought it was also interesting, the defense asked several people, well, if you're not a member of the group, is your significant other a member of the group? So that was significant to me. Also of note, of the 20 people that were brought in this morning, 6 said they were either domestic violence survivors or that they had been charged with domestic violence at some point. That question's being asked because the prosecution has said that Dee Warner was an unknown victim of domestic violence at the hands of Dale Warner. Court is breaking for lunch, and we're back in session at 1:30. Day 3.
Thank you very much. I like her. She's nice. Okay, so there's that. So Monday we'll be back. I don't know what we're going to do Monday, but we'll do something Monday. I'll stream something. And yeah, it's going to be quite a weekend because there's no football on this weekend, which sucks. But what can you do? Lonely weekend for me. But I'm going to practice on Streamlabs and take it from there, really. But thank you everyone for being here. I am going to have to put this in members only, as I say, just because of the judge saying it can't be replayed. So that's why I'll do that. But yeah. With that, thank you everyone. Love you all, most of you, some of you, and I will see you Monday. Have a great weekend. Behave yourselves, or try to anyway. So, and yeah, I'll see you all later. Right, let me figure out how to end the stream. Oh, I can do it here. Right, bye bye. Love you.